Вітаємо вас, пане Костянтине, на
Welcome,
другому
Konstantin,
етапі
at
відбору
the second
до
stage
конкурсного відбору до Вищої кваліфікаційної комісії суддів.
of our
Конкурсна
selection.
комісія проводить співбесіду з
And
вами
the selection
в
commission
повному складі.
is conducting this interview with you in its full composition. And let me mention these are Tkachenko, Ivan Mishchenko, Sergei Verlanov, Mezentsev, Steven Markman, and Robert Brugheisen.
Доповідачами на вашому інтерв'ю є мій
The
колега
reporter is
Ткаченко.
and me.
Пане Костянтине,
Konstantin,
якщо з якихось причин співбесіда
if for any reasons our interview is interrupted, we will definitely reschedule it for some other day and time, and we will definitely reach you to agree on that. During the interview, the commissioners will ask you questions. Our request is to give concise answers to the core of the matter, because the time is limited for the interview, and the commissioner shall be entitled to limit the time of your answer.
Перед початком, власне, співбесіди у вас буде
Before the
можливість
interview,
короткої самопрезентації до 5 хвилин.
you will have a chance to present yourself
про свою мотивацію,
and to tell about your motivation, about the ideas you have got concerning the operation and functioning of the HQCJ, and maybe the judiciary in general, or about any other things you consider to be relevant and important for us to hear from you. So with this, let me give the floor to my colleague Ted. You're welcome.
Thank you, Ivan. Good afternoon, Mr. Tkachenko. Mr. Tkachenko, as you know, our interviews are being live streamed, so I do intend to take just a moment to introduce our viewers to you and a little bit of your personal history and in the profession. You, sir, are 40 years of age. You were born in Kiev. And insofar as your professional life is concerned, you advise us that you have spent 15 years and 11 months of employment in the law. That work in the law consisted firstly as a brief experience that you had working in the prosecutor's office of Kiev City. And then you worked as a lawyer from 2005 until 2021 in various law firms. You worked as a senior legal counsel. You also worked as an individual entrepreneur. You were the founding member and partner and managing partner of a law firm, BKT Partners, in Kiev, where you have now worked for 9 years. In 2021, you were appointed Deputy Director of Corporate Governance Department of the State Property Fund of Ukraine. And later in that year, you were Deputy Director of the Department of the State Corporate Rights, all in the State Property Fund of Ukraine. You are married and you have 2 children. And my understanding is that you currently live in Ukraine. With that brief introduction, Mr. Tkachenko, I invite you now, as our chairman indicated, to provide further personal details or some introduction to your experiences in the law as you wish. So the floor is yours, sir.
Good afternoon, dear members of the Commission, dear representatives of the public, and all those who are watching this important selection process. I'm Konstantin Tkachenko, and I confess the principles of honesty, impartiality, incorruptibility, and diligence in performance of my duties. It was my conscious choice to obtain legal education in the Yaroslav Mudry National Academy, and I was referred to work to directed to work to the prosecutor's office in Kiev. Starting with the first day of my work in the prosecutor's office, I understood that this is not the place where I should work. I faced some of the things I had not been expecting during the period of my studies, and I saw a lot of drawbacks in the work of the law enforcement system, and I was not ready to somehow become a part of such system. And because of that, after a short period of time, I started my career as a lawyer in the private sector. I dealt with the representation of rights and interests of legal entities and individuals in civil, commercial, and administrative cases. I've got the experience of representation of clients in all instances, trial instance, appellate and cassation instance. As the rapporteur has mentioned, I worked for almost 2 years in the State Property Fund of Ukraine, where I got additional managerial experience and experience in the field of corporate management, corporate governance. Over the period of my work, I have seen a lot of drawbacks in the functioning of the judiciary, which result in a high level of distrust in the judiciary by the society. And of course, these drawbacks are to the detriment of the development of our state, and they make it impossible for the foreign investment to come to the country. And the problems about protection of interests of clients actually are to the detriment, are not possible under such circumstances. I decided that I realized that this system needs to be changed, and I've decided to participate in this selection in order to join in this process of change. And I actually participated in the selection to the Cassation Court. I passed all the selection stages, and I think that this selection process was important for me, was successful for me. I got the 17th place in the final ranking, but I did not become the judge of the Supreme Court because that was what the selection was about, because of the lack of vacancies. I decided that I would not stop at that, and that I will participate in this competition, in this selection for the HQCJ. The transparent and impartial format of work that I have seen here with the Selection Commission and this professional composition of the Selection Commission instills some trust in me. And I do believe that the newly elected composition of the HQCJ will really be exemplary and will be an example to follow in terms of integrity, impartiality, independence. And I hope that we will feel their contribution to the revival of trust in the judiciary. I think that the new HQCJ should be assisted in that by following the principles of honesty, clarity of the procedure, clarity of the criteria of assessment and scoring, independence of members of the HQCJ in their activity, their resilience and resistance to any external pressure, and, of course, cooperation but not adversariety with the Public Integrity Council, because, in fact, their objective is the same. And, of course, the HQCJ of Ukraine should be decisive in conveying its brave messages to all the entities that are in any way involved in the judicial reform. And let me add that we are living in a very difficult period, but this is the best time ever for radical and drastic changes. When the nation is getting united to win over the enemy, I think that we also need to win over the internal enemy, which is corruption and lack of efficiency of judicial protection. Thank you. That's it. I'm waiting for your questions.
Yes, thank you, Mr. Tkachenko, for those additional comments. I want to move now directly to issues involving you, of course, and your professional career and your hoped for and intended role as a member of the HQCJ. And I'd like to begin by focusing on your experience in 2018-19 as an applicant for the 16 vacant positions in the Cassation Commercial Court of the Supreme Court of Ukraine. You've already indicated that you have gone through all of the process that was in place at that time, administered by the High Qualification Commission for Judges. And somewhat sadly, I'm sure, or perhaps to your disappointment, you came to be ranked as 17 to fill 16 positions. So that I'm sure led to some disappointment on your part. But more importantly, you have personal experience, therefore, and very recent experience when you consider when the HQCJ members were terminated. Very recent experience with the process of the High Qualification Commission that you went through. We hear very many comments that there is a high regard that lawyers in the profession have for the Supreme Court of Ukraine, and presumably, therefore, for the work that the High Qualification Commission did in the years that you went through the process in order to fill the new Supreme Court of Ukraine. That brings me to ask you my question. Having gone through the process and procedure, knowing the professional and the public's reaction to the quality presently of the Supreme Court of Ukraine, what in your words or what in your thoughts were good about the HQC process? What is not so good? And what would you change if you were appointed a member of the HQCJ?
I have majorly positive experience as far as the work of the HQCJ is concerned, and the public majorly had a positive impression in the context of selection to the Supreme Court. The Commission worked rather openly, in an open manner, and the public came to like this, and I personally came to like this. The Supreme Court, as a result of that selection, was really kind of updated, and highly professional staff was selected to it. And it's good that these were not just people who were judges, but lawyers and scientists, researchers as well, because this contributed some fresh blood to the work of the court and improved the reasoning of court decisions, I would say. If we compare the structure of court decisions that are made by the current composition of the Supreme Court and the decisions that were passed by the Supreme Court of Ukraine about 7 years ago, it's incomparable. Quite often, the decisions of the previous Supreme Court were unreasoned and didn't contain any reasoning quite often. What I would change in order to raise the level of trust in the judiciary and in the selection processes, if I become a member of the HQCJ, I think that we should give a clear message about the principle of scoring and assessment by each and every criterion. I mean that we need to make it transparent how the score, how the points are distributed between different indicators within one criterion, because the scale of points is rather wide, and sometimes you may get the impression that there may be some manipulations hidden behind that, and you can adjust the scoring. Maybe it's also necessary to have the individual pooling each among the members of the High Qualification Commission and individual scoring to see when there is a change in the tendency in terms of behavior of a certain member of the commission, and to see whether any drastic changes occur and when they occur, and then try to find out what the reasons for that are. Also, the level of discretionary powers of the HQCJ could be changed. I mean, the share of discretionary powers of the Commission in the assessment of candidates should be reduced, should be smaller, because that will also raise the level of trust and create good grounds for claiming that the Commission is really independent and impartial and unbiased in its work. I also think that there should be more cooperation with the Public Integrity Council. We have all seen that there was a conflict in the work of the HQCJ and the PIC. The HQCJ probably set very rigid, too rigid criteria for the PIC, for the provision of information, and the time of the meetings was not always coordinated, though these were supposed to be joint meetings of the HQCJ and the PIC. So I think that there was some lack of cooperation between them. Also, maybe we need to improve the procedure for overcoming negative opinions of the Public Integrity Council. When there is such a negative opinion on this or that candidate. And also, I think that we should keep up with the times, and the assessment procedure should contain elements of automation. I mean, some types of testing could be automated. Online format could be applied if we have some methodology, not methodology, but ways to prevent any manipulations. And I think that there should be more active communication with all stakeholders. Here, I mean both the public and the PIC and mass media. Well, that's in fact it.
Well, thank you for that answer. It certainly covers a considerable amount of territory. I want to move to a matter that may be of some necessary comment from you. We have asked all candidates 10 questions as part of their motivation material. And question number 4 asks, please provide a statement addressing specific matters in your background that might raise concerns about your candidacy with the Selection Commission and your compliance with the criteria of integrity and professional competence that warrant the earliest possible acknowledgement, explanation, or clarification. Now, you basically answered that there are no specific situations in my experience that might cause concerns of the Selection Commission about your candidacy. Some of the information that we have been provided deals with certain associations, and I may say close associations that you have. Your wife, Olena Tkachenko, was an assistant to a member of parliament, Roman Babi, I think for a year until 2021. Your brother's wife, Natalia Blaszewska, is a judge of the Administrative Court of Cassation in the Supreme Court of Ukraine. Your brother's wife's sister is a member of the High Council of Justice and a member of the Second Disciplinary Chamber. And your brother's wife's father, his father-in-law, is a former rector of the National Academy of the Prosecutor's Office of Ukraine and Deputy Prosecutor General of Ukraine. Now, there are some who may be concerned that those close associations with persons involved in high office on the one hand, and with a member of parliament, a politician on the other hand, may raise concerns about whether or not any outside influence by these persons will be exercised upon you. And I invite your comment about any concerns that these circumstances may raise.
Okay, so let's focus on each of the items you have mentioned. As far as Natalia Blazhivska, the wife of my brother, is concerned, really, she is the wife of my brother, and Natalia Blazhivska is, as I've mentioned, the wife of my brother. But you can see this connection only on paper. Natalia Blazhivska herself shows this in her declaration of family relationship every day, because this is the duty of the judge. But in fact, in real life, we don't have any close relationship with her. And our communication is never related to any professional activity, and our communication is limited to some family relationship, like when we congratulate our children on their birthdays and on different holidays that Ukraine normally celebrates. Oksana Blazhivska, which is her sister, well, the level of communication in relationship is even lower. We don't have any common grounds even to communicate by phone. But legally, that's true. That is family relationship. And as far as my professional life is concerned, we have never had any relationship with them and never addressed each other for any help in our professional life. As far as the work of my wife as the assistant of Roman Babi is concerned, well, that's also true, but I wrote this in my written explanations, that first of all, as being an assistant to the member of the parliament is just the, being an assistant in terms of professional matters. This man is not engaged in any political decision making. And the assistant, of course, doesn't have this involvement in the political decision-making. That's what I meant. The assistant is just giving some consultations, recommendations, checks the information. So I can just tell you that we haven't had any relationship with this man since my wife left this position of being an assistant.
Yes,
That's all for me.
That's the question I was next going to very briefly ask, and that is whether or not your wife and or you maintain any contact with Mr. Babi, who's still a member of the Verkhovna Rada. All right, thank you very much. I am going to turn your questioning over to my co-rapporteur, Judge Verlanov. Oh, I'm sorry.
That's actually me. That's
Pardon me.
me.
Pardon me.
Well, I
Mr.
can pass
Chairman.
the floor to Judge
Yes,
Verlanov,
yes.
but still. Пане Костянтине,
So, Konstantin,
ви змінили свою професійну
you
кар'єру.
have changed your
Ви
professional
досить тривалий час
career.
були,
For quite a period of time, you used to be
commercial
a
lawyer,
commercial lawyer,
якщо так можна сказати.
if we
Зараз ви
may put it like
професійний
this, and now you're a
державний
professional
службовець.
civil servant.
Скажіть, будь ласка, з точки
Could you
зору
please tell us, from the point of view of some specific things and from the point of view of the civil servant, what are the complexities and the difficulties that you see in the work of the new composition of the HQCJ, and how are you going to overcome? How could these challenges be overcome? Well, the difficulties and complexities in the HQCJ will be, first of all, the complexity of funding, finance for its activity, because you know that the HQCJ and the secretariat of the HQCJ will really have to work a lot there will be high workload. I have not yet acquainted with the list of staff members and the amounts of functional salaries that are paid to the secretariat staff. I can just make some guesses. They are civil servants, so most probably their salaries are not going to be high. But the workload will be high, will be quite substantial. So the motivation for the staff of the secretariat will be very low because they will not be getting decent salaries. So we need to look for the ways of engaging the public and NGOs in solving some additional issues the HQCJ will be dealing with. And this is the matter of external communication, HR, services, development of test items, assignments, improvements in the very procedures, selection procedures. In particular, in my introductory speech, I already mentioned the possibility of having some part of testing automated or the whole testing automated. And with this in view, some amendments will need to be introduced into the applicable legislation right on the first day of the operation of the HQCJ, because if I'm not mistaken, the anti-corruption legislation has a ban for getting the money for the state institutions. Like they cannot be getting the money on a free of charge basis from some individuals or legal entities. So this means that there should be introduced an amendment which says that the money will go not to the account of the HQCJ, but to pay for the specific purposes that the HQCJ has. Let me still mention one more thing. When I was submitting my documents, I really was a civil servant, but now the data has changed. I've actually left my job. I left this job in October 2022, and now I've started practicing law again, and I'm now a sole proprietor again. I'm no longer in the state property fund of Ukraine. And what about civil service? Could you give us your impression of it? Well, you know, that was a useful experience, and it was worth doing. In order to understand what civil is all about, to understand what the challenges in the civil service are, to understand that the civil service lacks flexibility in terms of decision-making, also to understand that civil service is some place where staff members are afraid of any brave decisions because law enforcement bodies will approach them in 1 or 2 or 3 years for such actions, and rank-and-file staff members are always afraid. They are always summoned to law enforcement bodies and interrogated in a way for some brave decisions, and then they know that this will happen even if these decisions are right and useful. Thank you. I've got the answer to your question, but you left the job not because of that. No. Just when I applied for that job, I set a period for myself, and that was the period of 2 years, which would be sufficient for me to complete the projects for which I was involved to the State Property Fund of Ukraine, and to gain some useful managerial activity, experience, and then to move on in my life. You are a professional lawyer, a professional attorney, so there is a high chance that you will be a member of the HQCJ. So how would you then try to persuade your colleagues, attorneys at law, to become judges? What motivation would you give to them? How would you try to persuade the best specialists available in Ukraine to join in the judiciary? Because, you know, again, most probably this is not the easiest place to work at. Well, I agree. Not the easiest one. This is one of the toughest, one of the most difficult places to work, in particular if you're diligent about your duties, and the load of judges is quite high, taking into account the materials and the number of cases that we have because of the staff shortage. I'm sure that we should knock on the door. I mean, we should knock on the hearts of people, of the hearts of experts and specialists. We need to convince people that Ukraine needs their help badly. We need to convey the message to them that in spite of not high salaries, still judicial position is a very prestigious job. This is the indicator of the professionalism, high level of professional competence of a person. You need to talk about this, and you need to also say that insufficient funding for courts will not always be there. I win that after victory, after the reform, after recovery of Ukraine, there will be improvements. The overall level of well-being and economic growth and finance will become better, and in the judiciary it will all the more become better. In the judiciary you can actually grow in terms of your career, going from trial court to appeal, cassation courts. That is also all about challenges, about kind of competition. And some people really lack those challenges. They want to overcome some challenges because for them money is not the worst thing. They want self-fulfillment. Thank you. Thank you for your answer. And now let me give the floor to my colleague Robert. Robert?
Yes, I'm here. Good afternoon.
Good afternoon.
When I looked at your bio, I was wondering, because you were a professional lawyer, an attorney for quite some time. You went into this state property fund of Ukraine. Now you're a lawyer again. And now you want to select judges. And the first thing then that comes up to my mind is, shouldn't you first become a judge or something before you start selecting them?
Well, maybe you're right. And I actually tried. I made an attempt. As you remember, I applied to the Supreme Court and was almost a success. I actually do not exclude an opportunity like that for myself, but in fact, the selection that is now going on for the HQCJ of Ukraine precedes the selection that could be announced for courts, for judicial positions.
Yeah, I understand that. Of course, I know it was not possible. I understand it was not possible, but the reason I tell you is that I'm sitting now in the room for 3 weeks with 1, 2, 3, 4, 5 judges. And I can tell you they are very different animals to a attorney.
Well, and their job is different than the job of lawyers and attorneys, because their lawyers have to advocate the interests of clients, but the judge should find the middle, find the right balance, and the decision that would be considered to be a just decision following the law. It's not always the case that the position advocated by the attorney is represented in the court decision, is confirmed. So the approaches are different, not just the people are different. But of course, experience of the attorney is also very useful for when the attorney becomes a judge, because this enables the judicial practice to evolve, to keep up with the times, and not to lean towards the past.
You don't see any difficulty that you, as someone who has always, let's say, represented interests of somebody, suddenly is requested to select people who have to decide instead of representing only one side of the medal? How would you know how to select the proper people that are people who can make decisions, instead of people who are representing limited interests of their clients?
Well, in the selection process, it's important to assess not just professional competence and knowledge of a person whom you are assessing, of importance is also assessment of moral and psychological qualities of a person. And you can understand what a person is like during the interview. You can understand what life principles the person is following, what are the values he or she confesses. And on the basis of this, you can understand whether the person will be able to pass fair decisions and whether the common sense and the internal will of this person is really something that could be a good grounds for justice and fairness.
Yeah, of course, that's possible. But the question is, are you the one who's able to do that? What shows that you are the one who's able to do that? Because you have been always a lawyer in your whole life. You don't have specific experience in selecting people. And now you're here on the screen and you start explaining how you should do that. But you have never done it.
Yeah, I've never done this. That's true. But I've seen the work the judiciary works because I was rather an active lawyer, attorney at law, and I have accompanied quite a number of cases in court hearings. That's why I saw not just my own opinion and my own standpoint, but I also saw the standpoint of other parties, and I'm quite tolerant about somebody having a better reasoned arguments than I do. I also learn from other participants, other trial participants. I also learn from judges hearing the cases. And I learn from the decisions of judges. And sometimes I change my opinion concerning this or that issue because of the good arguments, because of good reasoning as the court practice evolves.
Okay, thank you. Let's see what the real judge thinks about this, Stephen.
Then let's go to Yevgen then if we're going to have to do that. Thank you. Thank you, Mr. Burkhuizen, and thank you very much, Mr. Tkachenko, for being here and participating in our competition. You say kind of a curious thing to me. In question 3, which asks about your ethical standards and, your respect for the law, you say, over my lifetime, I have not been brought to account for even exceeding driving speed. That's kind of what someone says when they have a very, very clean record. I've never even walked on my neighbor's lawn. You've never even exceeded the driving speed. And I believe that's true, but you have arguably violated the traffic rules even more severely when you caused damage to other vehicles at one point and were given administrative sanctions. Isn't that kind of a curious thing to put in retrospect? Maybe you should have talked about not walking on someone's lawn.
Thank you for the question. And I will mention why I have told about this over speeding. The point is that the format of the motivation letter asks us to give specific examples from life that would actually prove that you are a person of integrity. So it's rather difficult to find some examples from life under specific circumstances. I somehow failed to find a wallet in the street which I could return to the owner of the wallet. I didn't have any other situations that I could show in order to document it on paper that here I am, a man of integrity. I decided to give this example for speeding because I'm sure that this type of violation is the most widespread violation among drivers and one of the most dangerous ones as far as the consequences are concerned.
Let me try to ask.
I know that traffic accidents often result from overspeeding. Shall I continue? Yeah.
Okay.
So
let me move on. That is not the worst offense I've ever heard. I just found it a curious illustration, given the fact that you did have what was arguably a more serious traffic violation. But let me move on, please. Let me try to ask a real judicial question here, if I can do so. You have gone through now 2 competitive selection processes, right? This is your second competitive selection process. And no doubt these are very stressful exercises, but they have to be because they're in pursuit of something very important, a position on the Supreme Court or a position on the High Qualifications Commission. So I guess I'd like to ask you the obvious question. What have you learned, good and bad, from those experiences? If you're placed on the High Qualifications Commission, which you're also seeking, I would take it you would try to learn from your experiences, good and bad, would you not? What would you learn from those experiences? What would you want to try to emulate as a commissioner of the High Qualifications Commission, and what would you try to avoid? Maybe you don't think this interview is very good. Maybe there's something that you thought was, inappropriate in your previous selection process. But what's the good and the bad of it in your judgment? What have you learned from those 2 processes? We all learn from our life's processes, hopefully. But what have you learned?
Well, I have already mentioned, I mentioned this in the introductory speech, that the level of degree of discretionary powers for an HQCJ member should be lower in terms of scoring, because then it will be clear for everyone what the criteria for scoring are and why one candidate gets higher score and the other one gets lower score. In particular, I would mention assessment of the criteria of moral and psychological qualities of a person. There was a psychological portrait of an individual. There were some psychologist opinions, but nobody understood what should be the portrait of the judge who is elected and why that candidate got more or less or fewer points. So I think that there should be more clarity in this respect. Besides that, the very selection was very useful and very transparent in spite of these things I've mentioned. We hadn't had any such selection processes before, but there were some people who should not have taken part in the selection because of the positions they were holding. That spoiled the impression from the competition. But the new Supreme Court has really improved. It's working much more efficiently than the previous one.
Do you think that this commission, the Selection Commission, has been reasonably transparent, not only, of course, in these kinds of hearings and interviews, but in communicating our standards? You've probably read the methodology, which explains some of the standards in our assessment of candidates. Are those adequate? Are those reasonably clear? Is there sufficient specificity?
Well, I would say yes. They are rather clear and transparent. And this is, first of all, due to the fact that there is a high level of trust among the candidates in the selection, in the composition of the Selection Commission. I don't know how these criteria would have been used by some other composition of the Commission, but what we see now is that you're really following the criteria, and that makes us respect the Commission very much. Well, really, a certain degree of discretion is inherent in this process, in this selection. And we should also remember that we are at war now. There is war, there is aggression, so we should remember, we should bear this in mind, and it's very good that this selection is generally taking place in spite of what is happening at the border and inside our country. Of course, it would be good if that was face-to-face communication with the Commission, but the format you have suggested is absolutely applicable and acceptable, all the more that modern technologies allow us to do this rather efficiently. Otherwise, the selection would last for a long period of time, and we would not be able to see the new composition of the HQCJ in the nearest future.
But
As far as the procedures that I would add are concerned,
Well, before you go on, I want to respond. Hold on for a second, please. I mean, you've spoken with some disfavor about the exercise of discretion and not knowing, what the basis for that discretion was. But of course, that's reflective, too, of this interview process, is it not? After this interview, we're going to go back and talk about Mr. Tkachenko, and we're going to have discussions. He did this, he said that, this was good, this was not so good. You're not going to be apprised of those discussions or even the kinds of issues raised in the discussions beyond what's already set forth in the methodology. Is this really better from your perspective? Or are you looking for a more objective process, testing and those kinds of things? I mean, what are you going to do if you're placed on the High Qualifications Commission? What will you be favoring? What kind of process do you want to establish?
we should try to get rid of this subjective component, but not to the full. I mean that only the share of the subjective component should be reduced. I don't mean that discretion is really bad. It is a really bad indicator. When in the background of having full trust in the people who are holding the selection, if you trust them, discretion is okay, but the share of it should be reduced. And I think that the society, the public now means high level of openness and publicity. So I don't think discretion is a bad component, but it could be perceived negatively by the society and by the public. So the share of it should be reduced, and that's what I meant.
Well, good discretion and good judgment are good, and bad discretion and bad judgment are not so good, right? But as you say, you have to have trust in the people who are exercising that judgment and discretion. And how are you going to communicate to us, or how do you communicate to us that you'll be such a person on the High Qualifications Commission, a person whose exercise of judgment and discretion will be done right and done well in terms of repopulating the judiciary of your country? It's a pretty important exercise of discretion, isn't it? You can't make too many mistakes.
Well, to prevent these mistakes, we have a joint body and a joint procedure for decision-making. The decision of the HQCJ will not be based on my decision only. And the openness of the procedures that could be shown to the society actually reduces the level of distrust in the public. And you should always have the answer to yourself, for yourself as to why you have passed this or that decision. Of course, there is a certain degree of subjectivity in your decision, but you should be ready to always argument it, to always reason it on paper, if you can do this. I think this discretion has been used in the right way.
Okay, I appreciate your thoughts, Mr. Tkachenko. Let me pass you on to my colleague, Judge Mezentsev.
Thank you, Steve. Доброго дня, пане Костянтине.
Thank you, Stephen. Good afternoon, Kostiantyn. So, with regards to the degree of discretion within this selection, well, our competition is based on the discretion. We rely on our inner feelings, on our inner discretion, and we are trying to compensate for this level of discretion by having the transparency of the procedure itself, by having it broadcast, among other things. And the people who will be appointed as HQCJ members will pass through 6 rounds of assessment by different people, including our selection commission, analysts, and others who help us. So the level of control and the sieve itself, it's quite harsh. So you participated in the previous election to the Supreme Court, and you were the 17th in the competition where 16 vacancies were available. I don't know how you felt with these results. It must have been really unpleasant because you stopped short of being selected. You were just outside of the final list. But you also mentioned the assessment system, the objective and subjective indicators that must be balanced within the system. So, in your opinion, should we use this kind of sporting system in the selection? If we have 6 arbitrators, then we disqualify the highest and the lowest score, and we base our score on the other 4. In such a way, we eliminate the possibility of abuse when assessing athletes. So, in your opinion, is this kind of assessment appropriate for assessing judges? I have never thought about that, and that's why I asked you this question. That's what I thought. I'm not really aware of how athletes are being scored by arbitrators or judges. But if this is a way to eliminate some kind of abuse, so yes, we disqualify the highest and the lowest score, and then we have the average score, which we consider to be the final result for that athlete. So in your opinion, would it be objective to apply this kind of assessment towards judges? Probably not. I don't think it would be very objective, but it could be useful to eliminate any doubt with regards to abuse. So I think it's possible, but it could be discussed with the civil society, all the members of the commission. So at least I've introduced an idea which could be discussed within the future HQCJ. In your motivational letter, you also mentioned that you would do everything to select principled and resilient people. So you mentioned it, that these are people who are principled and resilient since day one on the job. I can tell you that since day one, on day one, on the position, the majority of people are principled and resilient, and they become worse with time. So do you have any ideas on how we could prevent this kind of deterioration of the quality of judges throughout their career once they've been judges for 10, 15 or 20 years? What kind of methods could you suggest? At least one. I think that this method is already being applied by some government bodies. That is the procedure for declaring income, declaring your expenses, something that is used by an ACP. It's already having a positive effect, but unfortunately it practically has no impact on the corruption perception index. So if we compare our ranking in that list, we've improved just by 1 place in that rating. So something is not working. Could you think of something more efficient? It has to be systemic work of all the government bodies, NABU, the prosecutor's office. And we also need to discover all those facts and circumstances. We need to hold specific judges accountable for specific offenses. Unfortunately, we don't have a sufficient number of verdicts that can be disclosed to the public. But I know that a lot is being done. We are already having the verdicts of the High Anti-Corruption Court with regards to some judges, and I hope that this work will be continued. We need for the whole judicial community to feel that the procedures are in place and that judges can be held to account. So you believe that the more judges we imprison or sentence, the better our fight with corruption is. So how is it going to work? I'm not telling you how to punish for corruption. I'm just asking you about eliminating any grounds for even having this corruption. I think that the reason for having corruption is not sufficient remuneration, but if we compare the courts with other government bodies, the salaries there are much higher, but still it's not enough to ensure that the judge is satisfied, because the level of responsibility is really high and judges can be tempted. I can tell you that you are talking about some high salaries not within courts, but just high salaries for judges. Fine. Let's not discuss the salaries anymore, but let's discuss the apartment which you bought in the year 2019 with the area of 49 square meters. You started indicating that you bought this apartment in the year 2015. You declared the price at 920,000 hryvnias, and civil society organizations mentioned that the initial price of $13,000 was a bit too low. And you explained the situation to the Commission when answering our question, but since we are being watched by an audience, it's important that the audience and the civil society in general understood how it happened. Could you please explain the situation with this apartment? So there was this mistake because we are having 3 different dates. The date of buying ownership rights for an object of incomplete construction, the date of registration of ownership, that's early 2015, and the end of 2015 is the date of appraisal. And because the 3 dates do not coincide, there has been this misunderstanding of the price of the apartment. It appears that the price increased from 10 to 40,000 over a period of 1 year. But I was buying property rights in the year of 2013. At that time, that was 44,000. Then there was repeat appraisal because I wanted to take out a mortgage from a bank. And according to the new exchange rate of hryvnia to dollars, the price became 38,000. So practically it wasn't an increase in the price, but a decrease in the price in dollars because of the change of exchange rate. And you have a mortgage on that apartment, yes? Yes, since the moment of buying property rights, I had mortgage on those property rights, and once the apartment was commissioned, I took out another mortgage for the apartment itself. Thank you, that's clear. And in the year of 2016, you've had some executive proceedings initiated against you. Could you please explain the circumstances? Yes, let me explain this briefly, but it should be explained in connection with that question that you asked me previously about violation of traffic regulations, the car accident. I don't think that that car accident should cast any doubt on my integrity, because that car accident did not result in any significant consequences. So I was not the one to blame for that car accident. I was moving along a narrow street between two other cars, and I just didn't calculate the size of my car, the width between those two cars, and I just scratched the bumper of the nearby car. So I called the police. They formulated the protocol, and I damaged my car more. And I also acknowledged that I was to blame for the accident, and on the day of getting the court decision, I paid the fine. I gave the receipt in exchange for the decision. So you know that this is the practice of our courts. So you can get the court decision in exchange for a receipt that you get when paying the fine. So that's what I did, and I forgot about that story. And approximately a year later, I discovered that my car was under arrest at the service center, and it was placed under arrest within executive proceedings. And the materials of the case were the same. I have already paid fine, but for some reason executive proceedings were initiated, and that was a mistake because there was a huge workload, and my receipt for paying the fine somehow got lost. And that's why the executive proceedings were initiated. So I went to the bank, I retrieved another copy of the receipt. I showed it to the enforcement officer, and the enforcement proceedings were closed. Thank you. Now that is clear. I'm not as perfect as you are, to tell you the truth. When getting my driver's license, I got some speeding tickets, but not that often. Thank you. With that, I'm passing the floor to my colleague, Serhiy Varlanov. Thank you, Yevhen.
Я хотів би повернутися
So,
до
Костянтин,
питання того, яке ви вже
let us go back to the question that you have already discussed with my colleagues. And that is the question of changes that are necessary to implement to enhance the level of trust in the judiciary. Since in your motivational letter you are using very general words and phrases, could you please be more specific?
Тому, що ви пояснили, а саме співпрацю, покращити співпрацю
Could you give us additional comment about the interaction between HQCJ and PIC and the improvement of the procedure for overriding negative opinions provided by PIC? Please, could you tell us a little bit more about the improvement of the procedure? What do you mean by that? I've heard that there is this debate within the subjects of the judicial reform on how to override negative opinions of PIC, and there is this proposal to have a joint meeting between HQCJ and PIC members. And as far as I understand, a formula is suggested which is as follows. A negative opinion can be overridden if at least half of the members of such joint meeting vote for this, and the PIC, at least half of their members, must vote for overriding their own decision. And it is suggested that this norm is enshrined in the state anti-corruption program. I understand why we are having this debate, because we already have a situation with a PIC having a negative opinion. And in the future, if they're going to vote on the same opinion again, there may be some level of bias on the part of PIC members with regard to this same opinion, because they have already prepared this opinion. They have formed some kind of impression about the candidate, and their role is going to be decisive when overriding such decisions. So I don't think it's highly likely that people who have already arrived at a certain opinion, for them to change this opinion.
Насправді, дійсно, не потрібно нам запроваджувати, нічого немає проти громадської
I have nothing against PIC, but I think we also need to have an understanding of the need for balance, of the need to be objective when making the decision. And we also need to think how it looks for an outside observer. And maybe we can have less tension when discussing the role of PIC if we implement the following. Let's keep the role of PIC as it is, but maybe let's have this joint meeting to override the negative opinions by changing the formula. So let it be half of all the members of the joint meeting, but not half of the members of PIC. So let's not talk about the majority, let's talk about 1/3 of votes coming from members of PIC. This, on the one hand, will not create this impression that PIC is acting as HQCJ, and as a result, there will be less tension. Thank you. While participating in the selection for the Supreme Court, did you have an opinion formulated with regards to your candidacy by PIC? No, there was no opinion from PIC about me. Thank you. I'm now passing the floor to our chair, Mr. Mishchenko.
Пане Костянтине, наша співбесіда з вами наближається до кінця.
Konstantin, your interview is coming to an end. Could you please summarize it, mention some important things? Perhaps there is something that you forgot to tell us in the course of the interview, something that you'd like to draw our attention to. You're welcome. Thank you. I would like to add a little bit about the feasibility of introducing the stage of interview into the selection procedure for judges and the involvement of PIC, because in the course of an interview we can discover a lot of information which can cause doubt during the stage of dossier inspection and studying of the documents. Even if a person has been excellent during their exam, it doesn't mean that they know how to put this theoretical knowledge to practice. It doesn't mean that their values, their life philosophy is what we are looking for. And that is something that could be discovered in the course of an interview. At the end of my interview, I would like to thank the members of the Selection Commission for giving me this opportunity. I would like to thank you for the time you have spent asking me questions. Thank you for this great contribution that you are making in the enhancing trust in the judiciary. I would also like to thank other candidates who have shared their ideas and opinions with regards to the operations of HQCJ. So this gives the Selection Commission an opportunity to choose the best of the best. And I also want to thank our armed forces for giving us the opportunity to have this selection. And I hope that in the near future we will see the victory of a strong, independent Ukraine, for the benefit of which the new HQCJ will be working. I trust in my own abilities And I believe that together with the new members of HQCJ, should I be appointed, we will be able to show a positive result, a positive outcome of the activities of HQCJ, such as a transparent and fair selection. Thank you. Thank you for your attention.
Дякуємо, пане Костянтин.
Thank you,
Наша
Костянтин.
співбесіда завершена. Всього вам
This is
найкращого.
the
Бережіть
end
себе і
of
до
your
побачення.
interview. Take care and goodbye. Goodbye.